Throughout history, the Supreme Court has always been controversial, ever since its founding to right now. The recent hot-button Supreme Court cases have been the Dobbs v. Jackson case, which overruled the case from the 1970s, Roe v. Wade, and that case had established that the right to an abortion was a right that women had basically had guaranteed to them by the Constitution. There was also the case D.C. versus Heller, which stated that anyone had a right to own a gun. Not to mention the Supreme Court case over Roosevelt v. Hodges, which had established the right to same-sex marriage across the country. And last but not least, the case Citizens United versus Federal Election Commission, which had established that corporations have the right to spend money, as much money as they want, for elections in which public officials are going to be elected. So right now we're going to be counting down the top 10 Supreme Court cases in my opinion. This isn't going to include any cases within the last 20 years, just so you know. So now let's get started. So number 10 is Tinker versus Des Moines. The Tinker v. Des Moines case is mostly important because of freedom of speech. This was a freedom of speech case. It all began when students, Quakers especially, named John F. Tinker and Mary Beth Tinker, both children, had decided to wear black armbands to their high school in order to protest the Vietnam War. The school learned about this, however, so they passed a law which would ban using black armbands and bringing them to school. However, the Tinkers, they violated this rule, and therefore they were suspended. The family then began to sue the school district with the help of the American Civil Liberties Union, a chapter of the American Civil Liberties Union in Iowa, which was where they lived. They had failed in the district court, and after that they failed in the United States Court of Appeals. After that, they appealed to the Supreme Court, which had agreed to hear their case. This case was interesting because there was precedent over, I think, 18 years ago in the Supreme Court case West Virginia versus Barnett, it was agreed by the justices that you had the right to protest, or you had the right to not pledge allegiance to the United States if your religion allowed you not to. And even then, they said that pledging to the United States flag was a religious issue. The Supreme Court case, ultimately, the Supreme Court justices agreed with the Tinker family and sided with them. This majority opinion was written by Justice Abe Fortas, who wrote that it could hardly be argued that students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse. Now, the dissent, on the other hand, was written by Hugo Black and John Marshall Harlan. Hugo Black argued that the First and 14th Amendments had basically stopped people from censoring any content of speech. However, he also stated that people just could not give speeches or engage in demonstrations wherever they wanted. And basically, Hugo Black was stating that by making a demonstration at the school, the students were disrupting the school. Therefore, they did not have a constitutional right to freedom of speech there. Meanwhile, John Marshall Harlan II wrote a separate dissent, stating that he found nothing in this record which impugned the good faith of the respondents, basically stating that there was nothing wrong with making armband regulations. The case is very important today, especially given the fact that this is what ultimately started many student rights cases later on, where students would protest or they would sue the schools over denying them constitutional rights. This was where that all began. And ultimately, this is also what caused the Tinker test, which ultimately stated that if you were making a demonstration at school which was not disrupting anything, it was fine. Number 9 is United States v. Lopez. This was a case with regards to federalism, or the power that the United States government and the 50 states governments had. Ultimately, this was over the Gun-Free School Zone Act, which was passed by Congress in order to regulate the guns that were used at school. The student, however, had violated this rule. His name was Alfonso Lopez, and he had brought a gun to school illegally, so he was put under arrest for this. Lopez had sued the school and brought this suit to the United States District Court for the Western District of Texas. His appeal failed there, so he later appealed to the United States District Court, which had stated that which had actually reversed his conviction, stating that the Gun-Free School Zone Act went beyond the power of the United States the United States Congress. So Lopez's argument was that the United States government had no right to regulate guns, as it hadn't said so in the Commerce Act. So the argument against Lopez was that guns did affect commerce, as, think of it like this: if you're in a place with more guns, there'll be more violence, and if there's more violence, the overall commerce of the city would go down. Therefore, it affects commerce if you're affecting guns. This argument was deemed as weak by the Fifth Circuit, and they overturned Lopez's conviction. The state of Texas then, however, appealed to the United States Supreme Court, which agreed to hear the case. Ultimately, the decision was written by William Rehnquist, who was a longtime supporter of states' rights on the Supreme Court. He had stated that the United States, that commerce and guns had no link whatsoever, and if you were able to link the two, you could basically use that link for anything you wanted, and Congress basically had no limits on it. The dissent was written by Justice Stephen Breyer, who stated that while he did not believe Congress had unlimited power, he said that gun control was a power that Congress had, as it did affect commerce. So this was one of the major cases which had actually limited the power of the United States federal government, and after a bunch of cases around the 1960s which had expanded the power of the government, this one was key in the fact that it limited the government. So next up, we've got Gideon versus Wainwright. This is a major case with regards to police and law enforcement, as well as a constitution with regards to the right to an attorney, or the Sixth Amendment. So a man named Lawrence Gideon was arrested under the charge. So Lawrence Gideon, he was arrested because Clarence Gideon, he was arrested because he was accused of a burglary. However, Gideon did not have enough money to fund a lawyer, so he had to act as his own lawyer during the trial, which did not work out for him. And the state of Florida, they had required that a person only had the right to a lawyer if it was a death row case. This was not a death row case. Therefore, Gideon had ultimately filed a case. He had ultimately filed to the Supreme Court of Florida, which had kept the ruling of the district court. So then, when he was in prison, Gideon hand-wrote an appeal to the United States Supreme Court stating that his rights were infringed. So the Supreme Court agreed to hear his case, and ultimately Gideon was suing a man named Louis Wainwright, because Wainwright, he was, I believe, hold on a second. Yeah, so Wainwright, he was the, Wainwright, he was the secretary of the Florida Department of Corrections, and Gideon argued that he denied him of his right to counsel. Therefore, Gideon had sued him. The Supreme Court had finally heard the case, and ultimately, this was after a previous ruling which had established that there was this was the previous ruling, Betts versus Brady, which had basically stated that you only had a right to counsel in the case of a death row. This was overruled by this case. And ultimately, Clarence Gideon got to walk free because the court argued that he had a right to a lawyer in all cases, and if someone was not wealthy enough, the court had to give them a lawyer. So there you go. Now, number 7 is Texas v. Johnson. This is another free speech case. So this had occurred this is actually very controversial today, especially with regards to flag burning. So, it all began when a man named when I believe, yes, his last name was Johnson, and he was a member of the Texas, and he was a part of the Communist Party. His name was Gregory Lee Johnson. He was a member of the Communist Party, and he wanted to burn the United States flag. Ultimately, this was illegal, however, in the state of Texas. So he was arrested. Later, Johnson, he had appealed his conviction to the Fifth Court of Appeals in Texas, but he was again found guilty. Then he appealed to the Texas Court of Criminal Appeals, which overturned his conviction, stating that his rights had been violated. So after this, the state of Texas appealed to the Supreme Court, who agreed to hear his case. William Brennan wrote the majority opinion for the court, arguing that the right to burn the state flag is a constitutional right, stating that if there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable, stating that Johnson's act of burning the flag was a symbolic gesture of free speech. William Rehnquist, on the other hand, wrote the dissenting opinion, stating that the flag is not simply another idea or point of view competing for recognition in the marketplace of ideas. Millions and millions of Americans regard it with an almost mystical reverence, regardless of what sort of social, political, or philosophical beliefs they may have. Ultimately, another interesting thing is that two justices, Anthony Kennedy and Stephen Breyer, also wrote their own opinions. Breyer wrote his own dissent, while Kennedy wrote his own concurrence. Ultimately, this case was key in establishing that people had the right to burn this flag. The immediate response to the case was initially very unpopular, and there were protests about it. However, this case is very important because it basically states that symbolic speech is also protected speech under the Constitution. Now, an interesting fact is actually that Justice Antonin Scalia, who is now one of the or the late Justice Antonin Scalia, is regarded as one of the most conservative justices during his tenure on the court. However, he had actually sided with the majority when it came down to this case. Number 6, Engel v. Vitale. This was a case regarding religious freedom, particularly in schools. So this case was brought when a group of Jews, as well as a few atheists who did not have any religious affiliation, had sued the Board of Regents of the state of New York because they had provided a prayer for students. The prayer was completely voluntary, however, and the prayer was voluntary though. And because of this, the parents who sued the school board president, William J. Vitale, and they were led by Stephen Engel, they had stated that this had basically established it was respecting an establishment of religion, and the school, by doing so, was violating the First Amendment. Now, even though the First Amendment states that Congress only cannot respect an establishment of religion, the argument at the time was that the 14th Amendment incorporated this into the states. Therefore, the school had to follow through with it. Ultimately, the case was appealed to the United States Supreme Court after they had failed in a court in New York. So, ultimately, the opinion was written by Hugo Black, who stated that it is neither sacrilegious nor anti-religious to say that each separate government in this country should stay out of the business of writing or sanctioning official prayers. The dissent was written by Potter Stewart. He was the only dissenter. He stated that stuff like "In God We Trust" was all over stuff like coins and paperwork, and that the students were not having their rights infringed because the prayer was voluntary. Therefore, the ultimate impactful thing about this case is that it basically states that prayer, even if it's voluntary, or any sort of religious stuff in schools, is not allowed. Of course, this is still allowed in private schools, but public schools are by no means today allowed to participate in any sort of religious thing. And this case was very important for people who had advocated for a separation of church and state. However, many evangelicals have decried this case, stating that it basically is bad and that it's basically the reason why there's so much immorality in schools today. Number 5 is United States v. Nixon. This was a major case with regards to presidential power and whether or not the president is above the law. So, I'm pretty sure everyone who's watching this video right now is familiar with the Watergate scandal, which ultimately ended Richard Nixon's presidency. If you're not, then let me just break it down for you. The Watergate scandal was an event in which basically Richard Nixon's campaign had basically organized a break-in into the Watergate building, which at Washington, D.C., or the Watergate Hotel, which basically was the Democratic Party's national headquarters. And ultimately, the burglars were caught, and it was suspected that the Nixon administration was involved, which is why as it was recorded in certain tapes. So ultimately, though, the private counsel who was investigating the Watergate burglary had subpoenaed these tapes. Nixon refused to hand over the tapes, stating that he had presidential privilege. And Nixon's attorney argued that the president wants me to argue that he is as powerful a monarch as Louis XIV, only 4 years at a time, and is not subject to the processes of any court in the land except for the court of impeachment, basically stating that the president was above the law except in cases of impeachment. However, the United States Supreme Court, after being appealed, had argued that it was otherwise. The case was agreed by the Supreme Court agreed to hear this case, and a few justices were actually appointed by Nixon onto the court, such as William Rehnquist, who had previously served as Nixon's assistant attorney general. He had decided to recuse himself from the case because numerous people that he had worked for, such as John Mitchell, the current attorney general, were under investigation. Warren Burger had ultimately wanted to write the majority opinion, but it was eventually decided that all of the justices would write the opinion. The opinion was stated that absent a claim of need to protect military, diplomatic, or sensitive national security secrets, we find it difficult to accept the absolute confidentiality of presidential communications, basically stating that Nixon's tapes, as they were not necessarily needed to protect them. They were not necessarily military tapes, or they weren't necessarily diplomatic or national security secrets. Therefore, they were able to be subpoenaed. They were not under presidential privilege. This case was pretty impactful in terms of limiting the scope and power of the President of the United States, stating that no one, even the President, is above the law. And ultimately, this was a unanimous decision in which all 9 justices, or pretty much, all 8 justices, with the exception of Rehnquist, had agreed on. Next up, we have Miranda versus Arizona. Now, Miranda versus Arizona, I'm pretty sure most people know about something which is called a Miranda right, which basically states that the police, whenever you're being arrested, they have to inform you that you have a right to remain silent and that anything you say will be used against you in court. So, this basically began when when a criminal, his name was, it was Ernesto Miranda. He had been arrested for raping an 18-year-old woman. He was under suspicion for doing so, and after a police interrogation, which was quite violent, he had fessed up to the crime, and he had wrote down and signed that he was guilty of the crime. However, after being convicted, he had appealed to the Supreme Court of Arizona, stating that he was not informed by the police that he had a right to remain silent. So, ultimately, after failing his appeal to the Arizona Supreme Court, which stated that Miranda did not specifically request an attorney, and that the police had not actually denied him of an attorney, his lawsuit was invalid. So after this, Miranda had appealed directly to the United States Supreme Court, and ultimately the court had issued a very close 5-4 decision. The majority opinion was written by Justice Earl Warren, who stated that the person in custody must, prior to interrogation, be clearly informed that he has the right to remain silent and that anything he says will be used against him in court. He must be clearly informed that he has a right to consult with a lawyer and to have a lawyer with him during interrogation, and that if he is indigent, a lawyer will be appointed to represent him. Basically stating that since the police did not tell Miranda that he had a right to remain silent, the conviction was invalid. Meanwhile, the dissent was written by Justice Byron White, who had basically claimed that there was nothing in the Constitution which stated that the police had to explicitly tell that he had a right to remain silent. This case drastically altered criminal law. Basically, is the reason why we have Miranda warnings right now. And an interesting thing is that many of the justices who were against this case, or future justices, such as Justice William Rehnquist, later actually affirmed the case again in a future case, and actually reaffirmed Miranda versus Arizona. Initially, this was actually a very unpopular case, because it would basically made it so that people could get away easier with crimes. But over time, this has become such a key part of American law, as well as culture. Number 3, Brown versus Board of Education. This was a civil rights case with regards to equal rights under the law for all people. During the time, there was widespread racial segregation after the Supreme Court case Plessy v. Ferguson, which had basically established that you had a right, that basically segregation was okay as long as it was separate but equal, and that the races were given equal accommodations. This, of course, did not happen, but the United States was in a period known as the Cold War with the Soviet Union, and racial segregation across the United States made the image look bad to the Soviet Union, or across the world, because of our fight against communism. And this was ultimately a case in the city of Topeka in Kansas. So a main issue with this was that a major issue was over the issue of segregation. And ultimately, hold on a second. Yeah, so ultimately, this was a major case over the issue of segregation. And there was a class action lawsuit filed against the school board in Topeka, Kansas for allowing racial segregation. There were 13 Topeka parents who had filed a lawsuit. So, after failing in the United States District Court of Kansas, which basically affirmed precedent in Plessy v. Ferguson and wanted to stick to precedent, they had appealed to the United States Supreme Court, which had agreed to hear the case. 4 justices had stated that they would actively want to overturn Plessy versus Ferguson, and among them was Justice Hugo Black, who you can see in the second portrait. The interesting thing about this is that Hugo Black was actually a former member of the Ku Klux Klan, who had used his membership to get elected to the United States Senate in Alabama. And now this same person who is a Ku Klux Klan member is stating that he wants to overturn racial segregation. On the other hand, there were 5 justices who were either undecided or willing to vote no on the case. Among them included Chief Justice Fred Vinson, as well as other justices such as Tom C. Clark, as well as Felix Frankfurter, and Robert Jackson, who had both been actually opposed to racial segregation, but at the same time, they did not want to overrule precedent, and they were against judicial activism. Not to mention the fact that there was also Justice Stanley Reed, who you can see in the second picture, who believed that actually segregation had benefited both blacks and whites. Ultimately, though, after Fred Vinson's death, this case, which was previously seen as a lost cause, was now again revitalized, and there was a belief actually that segregation could be overruled. So after Vinson's death, he was replaced by Justice Earl Warren, who was appointed by President Dwight Eisenhower. Ultimately, Warren had convinced both Reed and Jackson to drop their dissents and join the majority opinion. For Earl Warren, it was important that there would be a unanimous opinion in overturning racial segregation. Ultimately, in a unanimous decision, racial segregation was overturned, and basically it was stated that the majority opinion stated that we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that plaintiffs and others situated for whom the actions have brought are, by reason of the segregation complained of, deprived of equal protection of the laws guaranteed by the 14th Amendment, stating that by separating accommodations between the races, that was inherently unequal. This was a big change, as it had fundamentally based, and as many states during this period of time, even some northern states like California and states like California had racial segregation. It was not only the South. And speaking of the South, this was a major victory for the civil rights movement. However, there was a big backlash against this case, especially in the South, where basically tons of Southern whites were opposed to integrating schools. This had become a major conflict also when the governor of Arkansas, Orville Faubus, had decided to basically send the Arkansas National Guard to stop the students, or also known as the Little Rock Nine, from attending a school that was set to be integrated. Number 2 is McCullough v. Maryland. This is actually, in my opinion, the most underrated case. This case was basically with regards to the National Bank, because we were at war with the British, so Congress had decided to establish a second national bank after the first one had lost its charter. The state of Maryland did not really like this bank, however, so they placed a tax on it, in which basically $15,000 was collected from basically any bank which did not have a state of Maryland stamp on it, basically the national bank. So the bank's clerk, McCullough, did not like this, and he basically did not even pay the tax. So he was fined for this, and then he sued the state of Maryland and brought and appealed to the Court of Appeals for Maryland. This, however, had failed in the Court of Appeals, which basically stated that the Constitution did not explicitly say that Congress had a right that Congress could establish a bank. Therefore, the bank was unconstitutional. So McCullough appealed directly to the United States Supreme Court, and the decision was written by Justice John Marshall. This was a unanimous decision in which John Marshall had stated that the argument of strict constructionism, or the idea that it has to be directly there in the Constitution or it isn't there, like word for word, is false. Because of the necessary and proper clause, Congress is allowed to create a bank as it relates to the commerce of the country. Therefore, the bank is constitutional. This case is pretty big with regards to the reason why Congress can make laws right now that pretty much are not directly stated in the Constitution. Laws such as health care and stuff like that, basically, which is why Congress has the power it has today. If not for this case, Congress would basically have, or the federal government, in fact, would have absolutely no power. And number 1 is Marbury versus Madison. This case is the reason why the Supreme Court has so much power today. If not for this case, then pretty much all the previous cases would not have even happened. So this case had happened. So the origins of this case are that President John Adams had lost the 1800 presidential election to Thomas Jefferson. So he and numerous other Federalists had wanted to basically wanted to appoint a bunch of judges to numerous he wanted to appoint a bunch of judges, basically. These were known as the Midnight Judges by opponents of Adams. James Madison, however, had failed, or he didn't want to, deliver the commissions of many of these judges. By this point in time, Thomas Jefferson had taken over as president, and he ordered Madison to terminate any commissions, which Madison did. This upset a man named William Marbury, who wanted his commission to become a judge in Maryland. Therefore, he had filed a direct case to the Supreme Court, stating that in the Judiciary Act of 1789, that basically he could make a direct appeal to the Supreme Court because of Section 13, which stated that in any case in which a defendant, he has a right to issue a writ of mandamus, or they have a right to issue a writ of mandamus to the Supreme Court, in which so basically Section 13 had allowed Marbury to issue a writ of mandamus to the Supreme Court, in which the writ of mandamus would tell Madison to basically give Marbury his position as a judge. However, in a section of the Supreme Court a section of the Constitution with regards to the Supreme Court, it stated that in all cases affecting ambassadors or public ministers and consuls, the Supreme Court shall have original jurisdiction, and in all other cases, it would have appellate jurisdiction. This case did not affect any ambassadors or the United States government, even though Madison was technically the Secretary of the State. The Supreme Court did not find that, and therefore it was under appellate jurisdiction, and since Marbury was directly appealing, this was not true. Therefore, the Supreme Court struck down Section 13 of the Judiciary Act of 1789. Now listen carefully. This is key, because by doing so, John Marshall has stated that any law or anything which contradicts the United States Constitution is null and void, and that the Supreme Court can do so. Even though the fact that the Supreme Court can do so isn't even in the Constitution. This is today known as judicial review, which is the idea that the Supreme Court can declare a law null and void. And it's in fact because of this that all the previous cases which I just mentioned are even able to happen. In fact, this has expanded beyond the federal government to even state governments, given the fact that because of the 14th Amendment, which applies that if the states deny someone of their rights, it basically states that the states cannot deny someone of their rights without due process before the law, which is what our Section 14 of the Constitution states. And this is in fact the reason why the Supreme Court is the powerhouse it is today. So anyway, thank you guys all for watching this video. Make sure to like this video and subscribe to the channel. And yeah.